Good morning, everyone. Welcome to the Justice P.N. Bhagwati Memorial Lecture on the topic, The Journey of the Supreme Court of India on Fundamental Rights. A very warm welcome to our distinguished guests, cherished colleagues, dear students, and members of the audience who have joined us for this very significant lecture. Today, I'm delighted to welcome Mr. Tushar Mehta, Solicitor General of India, who will be delivering this lecture. Before we begin, I invite our distinguished guests to please offer the floral tribute in memory of Justice P.N. Bhagwati and commence the event with the lighting of the lamp.
Today, as I mentioned, is a very, very important day in the history of our university and our annual initiative that we have here. We are hosting Mr. Tushar Mehta, the Solicitor General of India, for having accepted to deliver the Justice P.N. Bhagwati Memorial Lecture. Justice Bhagwati does not need any introduction to the world of law, not just in India, but around the world. On a more personal note, I had the privilege to know Honorable Mr. Justice Bhagwati and his wife, Mrs. Bhagwati, for a very, very long time, from my student days in the 1990s from law faculty, Delhi University, but all through those years when they used to frequent New York and Geneva. But more importantly, when this idea of building the university came to me as a student in Oxford in 98, one of the first persons I discussed the idea was Justice Bhagwati, long before I had any plans to actually move to India and do this. And not only Justice Bhagwati supported it, but galvanized so much of consciousness, and there are some early letters and documents and quotations about this, what this university will end up become in the future. We have those things, and I am so privileged that he was part of that early evolution. So I want to take this moment to thank Honorable Mr. Justice P.N. Bhagwati, but also his wife, and over the years, his daughter Pallavi Shroff. In fact, on 11th, 12th, and 13th of August 2006, when we hosted the first international conference on the theme Access to Justice, Law, Policy, and Institutions, Pallavi spoke in that conference. Again, that was a conference which was a prelude to the idea of this university, and she supported our endeavor and remains a very, very active supporter in our endeavor, both Shardul and Pallavi, and of course in Cyril and others. I'm also grateful to Sonali Bhagwati, who is the daughter of Justice Bhagwati, who is present here. Sonali makes it a point to be present here at this lecture, so I'm deeply grateful to her for taking the time and the effort to be here. I am also grateful to Mr. Tushar Mehta for a number of reasons, but most importantly to recognize the importance of this event and also to accept our invitation to take out time from his busy and hectic schedule in Delhi and to be present here today. Mr. Tushar Mehta is one of India's leading lawyers, a distinguished advocate, a senior counsel, but more importantly, the Solicitor General of India. He traverses across many difficult and complex issues in which he defends the government of India, and quite ably, in an environment where courts are playing obviously a very central role in the evolution of our own democratic institutions. Mr. Mehta also has been a great supporter of our institution for a very long time. There are numerous situations as an institution we need to deal with, and I can only say that he has been an ambassador at large for OP Jindal Global University, Jindal Global Law School. He has never said no to any of our requests. He has constantly been a great source of inspiration for me personally for supporting this endeavor. He has attended several of our events in Delhi, and it has been quite a while since he last came to our campus, and today we are very fortunate that we are hosting him on our campus. Lastly, I want to say that the extraordinary contribution of Justice P.N. Bhagwati as a jurist, as somebody who has shaped the future of law and jurisprudence, has influenced not just India, but the entire world. But unlike many other judges who have had very good tenures as judges, Justice Bhagwati was one such person who transcended the boundaries of law and justice in India, but also was recognized for his contribution in the world. He served quite ably in the United Nations Human Rights Committee for very many years, was responsible for the evolution of national human rights institutions around the world, including the idea of NHRIs. Today, over 150 countries in the world have established national human rights commissions, and Justice Bhagwati played a very significant role. He also contributed to the International Commission of Jurists. He has been a very active member of the United Nations system, always available to be able to be an independent voice for speaking truth to power, not just in India, but also around the world. He also contributed to the evolution of a number of institutions within India, and we pay tribute to him for all of those contributions as well. Another thing about Justice Bhagwati is that he enjoyed interacting with students and faculty. He delivered lectures around the world and across India. He has a very had a sense of academic bent of mind, where he was combining the rich tradition of a lawyer, a judge, a jurist, and an academic when he engaged on complex issues of law and policy. So we are truly grateful to have this opportunity to host this lecture every year, and to have another distinguished jurist, Mr. Tushar Mehta, to be able to deliver this lecture. Thank you very much.
I now request Professor Dr. Khushbu Chauhan, Associate Professor and Associate Dean, Jindal Global Law School, to please share the introductory remarks.
Good morning, everyone. Welcome to the Justice P.N. Bhagwati Memorial Lecture, an occasion where we commemorate the life and legacy of a towering figure of the Indian judiciary. Today, we gather to delve into a theme that resonates deeply with Justice Bhagwati's lifelong commitment to justice and human rights, the journey of the Supreme Court of India in fundamental rights. Throughout its history, the Supreme Court of India has been entrusted with the solemn duty of upholding the fundamental rights enshrined in the Constitution, ensuring they remain inviolable and sacrosanct. This journey has been marked by numerous milestones, challenges, and triumphs, shaping not only the legal landscape of the nation, but also the fabric of Indian democracy. Justice P.N. Bhagwati, a luminary in the realm of Indian law, played a pivotal role in advancing the cause of fundamental rights during his tenure, both as a judge and the Chief Justice of the Supreme Court of India. His visionary judgments and unwavering commitment to justice have left an indelible mark on the jurisprudential landscape of India, inspiring generations of jurists, lawyers, and human rights activists. As we reflect on the journey of the Supreme Court of India on fundamental rights, we are confronted with a myriad of questions and considerations. How has the interpretation of fundamental rights evolved over the years? What landmark cases have shaped the contours of constitutional jurisprudence in India? What challenges lie ahead in safeguarding and expanding the ambit of fundamental rights in an ever-changing society? In this memorial lecture, we are privileged to have Mr. Tushar Mehta, Solicitor General of India, a distinguished speaker who will offer his insights, perspectives, and scholarly reflections on this dynamic theme. It is our fervent hope that through the discourse, we can honor the legacy of Justice P.N. Bhagwati and reaffirm our collective commitment to the ideals of justice, equality, and dignity enshrined in the Constitution of India. Once again, we extend a warm welcome to each of you. We are confident that this lecture will serve as a catalyst for meaningful dialogue and introspection on the journey of the Supreme Court of India in upholding fundamental rights. Thank you.
Thank you so much, Professor Chauhan. I now invite Professor Dr. S.G. Srijit, Executive Dean, Jindal Global Law School, and Dean, Strategy and Institution Building, OP Jindal Global University, to share his reflections on Justice P.N. Bhagwati's life and contribution.
Good morning to everyone, and welcome to Justice P.N. Bhagwati Memorial Lecture on the theme, The Journey of the Supreme Court of India on Fundamental Rights. I'm truly honored that I've been chosen to speak about the life and contributions of Justice P.N. Bhagwati. Generally, I get to give the introductory remarks, so this has been a sweet departure. Let me start by tearing out a page from fiction, a novel by Anand with the title, The Tales of Govardhan. You might have all heard about the popular drama Andheri Nagari Chopad Raja by Bhardendu Harishchandra. At the end of the novel, Govardhan, the protagonist, gets hanged for the simple reason that he happened to have a slender neck. Anand in the novel, Govardhan's travel, comes to liberate Govardhan from the death sentence and let him be free. He goes across historical timescales, transcending times, wandering like a vagabond, asking the question, what was my crime? My crime was that I happened to have a slender neck. I wanted an answer for the question, why was injustice meted out to me? I wish he met Justice Bhagwati, because in the novel he meets Amir Khosru, he meets Kalidasa, he meets Gandhi, and he's asking the question, or he asks the question, why? What was my crime? Why justice was denied to me? I wish he met Justice Bhagwati, because Justice Bhagwati was a voice of the voiceless. He was a representative of the unrepresented. And for that sole reason, I believe this tale of Govardhan deserves mention here. Justice Bhagwati was a self-perfecting man. A self-perfecting man is the one who's in a constant pursuit of one's own beingness. He never hesitated to regret. He never hesitated to apologize. He regretted for his judgment in ADM Jabalpur, and he used this beautiful expression, I plead guilty. I plead guilty for an act of weakness. He gave an interview in 2013 in which he was candid enough to say that it takes courage to plead guilty when you sense that you have been part of a collective wrong, not an individual wrong, but you have been part of a collective wrong which the Supreme Court of India at that point committed. And subsequently, Supreme Court too corrected itself for all the mistakes it did in ADM Jabalpur, subsequently in Ramdeo Chauhan versus Bani Kandas in 2010. He believed that Supreme Court could have acted better during the days of emergency. The guilt was so profound in his mind, because you know why? Because he felt that ADM Jabalpur denied life to an individual, a life that was already well defined by the Supreme Court. Had it been a life which was not well defined, he would not have felt this profound sense of guilt. But Supreme Court denied a life which it itself built through many of its judgments. He never dictated any judgments. I would say this is a great act, because when you don't dictate the judgment, you feel the text. The feel between the text and the text maker can often let the emotions to pour down in the judgment. When he wrote, ink became the liquefaction of emotions. And of course, you know that this is not like an overstatement, because we have heard about this expression, emotional liquefations. So he wanted to feel that relationship between the text and the text maker, so he never dictated his judgments. As I mentioned, the self-correcting of the Supreme Court and Justice Bhagwati, there's a relationship between both. Emergency gave the court a great awakening about its own limitations. For the first time, the Supreme Court thought that all the claims about the judicial supremacy, which it had developed over the couple of decades, were all wrong. The subsequent willing and acting of the court, the willing and acting subsequent to the emergency, was out of the sheer guilt of the court. The court went on to reclaim its glory, and Justice Bhagwati played a big role in reclaiming this glory of the Supreme Court past emergency. And Supreme Court arose like a phoenix through the ashes, or from the ashes through Article 14 and Article 21, and Supreme Court would witness, or rather India would witness, extraordinary decisions coming from the Supreme Court through Article 14 and Article 21, and Justice Bhagwati was instrumental in that. He always used this expression, I molded the law after the emergency. I got an opportunity to mold the law. He repeatedly used this expression, molding, and that's exactly what Justice Bhagwati did. So he played a remarkable role in rebuilding this. Now, this rebuilding has something sweet about it. There is a novel by Italo Calvino with the title Invisible Cities, in which he speaks about a city called the Clarice. Clarice has a rare quality that after every century, Clarice will go into dissolution, an absolute decay. And from there, it will resurface again as a better state, yet it will retain, or it will become an unparalleled model of its old glory. That's exactly what happened with the Supreme Court post the emergency. It was not just a reclamation of an old glory. Supreme Court rediscovered itself in the disappointments of emergency through the possibilities of fundamental rights. Particularly looking at Justice Bhagwati, especially the role he played with Justice Krishna Iyer in reshaping the Supreme Court, or in reclaiming this glory, or in rebuilding the Supreme Court, I would just summarize this with this expression: he sung the melodic duet of justice along with Justice V.R. Krishna Iyer. I would not speak much about their joint work in the Supreme Court. Some of his judgments we all know: Maneka Gandhi versus Union of India, Hussain Ara Khatun versus State of Bihar, where life and personal liberties, he mentioned, can be taken away only by the procedure established by law, and that procedure established by the law shall be just, fair, and reasonable. And to this justness, fairness, and reasonability, he added these high values of due process, natural justice, and access to justice. He sowed the seeds of public interest litigation. And that's based on a profound philosophy that Justice Bhagwati had in his mind. He wanted the wrongs to speak the language of the rights. Representation, he believed, is the key to justice. And he really wanted the third-party representation for the unrepresented, which he explored through a term which Justice Krishna Iyer later on popularized: epistolary jurisdiction. That means deemed to be writs. A letter written to the court will be deemed to be a writ, and the court will take cognizance of the matter. He was, in fact, deformalizing the justice to take it to the unrepresented, to the simpletons who lived in the peripheries. On environmental matters, Justice Bhagwati believed in sustainable development. Remember, we are talking about 1984 and 85, and sustainable development is yet to take proper shape. Justice Veeramantri is yet to give the judgment in Kapshikavu Najimaro's case, where he waxed eloquent on sustainable development. At that point, Justice Bhagwati, through MC Mehta versus Union of India, developed the notion of sustainable development by explaining the act of balancing development with environmental protection. But don't take him for granted. He took a strict stance when development crossed all boundaries of sustainability, as in the Doon Valley case, rural litigation entitlement Kendra Dehradun versus State of UP, where he daringly decided to shut down all the quarries which damaged the beautiful Doon Valley. Subsequently came his landmark decision in Francis Corelli versus Union of India. Of course, this is a case generally we study in the constitutional law case as a case that defined the idea of life. But if we look at the Justice Bhagwati's judgment here, you would find that he defined life as facilities for reading, writing, and expressing oneself in diverse forms. He defined life as an opportunity for catharsis, or rather he found self-expression as a means of catharsis. That's exactly what he did in this case. So the sum total of all the rights, according to Justice Bhagwati, is the bare minimum expression of the human self. This particular element in Justice Bhagwati's decision was later on used to define dignity in both NAS foundations and in Navtej Singh Johar. I always believe that he, in a typical Heideggerian fashion, he was in search of his beingness. He believed that the Dasein, the Heideggerian Dasein in material and historical conditions, all the time is in relentless pursuit of the meanings of life. And Justice Bhagwati became an answer, or rather he gave answers for that big existentialist questions. Who am I? Why am I here? What causality had me doing things? On a lighter note, I could see Justice Bhagwati comfortably sharing a coffee with Jean-Paul Sartre, Simone de Beauvoir, and Mario Ponti in the proverbial existentialist cafe. And that conversation will have no oddity of a jurist's presence there. Lastly, Justice Bhagwati was a scholar par excellence. We are familiar with Justice Bhagwati primarily through his judgments. Seldom his academic writings are taken note of. And I found that those academic writings of Justice Bhagwati are afterthoughts of his own judgments. He wanted a little bit of value talk on those judgments which were constrained by constitutional imagination, which did not give much space for the value talks. And most of these value talks were on themes which were otherwise parts of his own judgment. So he added a new layer of reasoning through his academic writings by taking positions outside the, if I may use this word, elite discursivity of judiciary, so that his discourse or the judicial discourse could reach the public more easily. He wrote this piece, Human Rights in Criminal Justice System, in Journal of the Indian Law Institute in 1985, where he went on to explain or wax eloquent on procedural justice. Another beautiful article with the title Bureaucrats, Phonographers or Creators, which he published in Times of India, he went on to say that one of the primary functions of the court is to share the passion of the Constitution, something you generally don't get to read in a judgment. And lastly, Justice Bhagwati also wrote a case book on income tax law for the students of the law school. Now, what's better to be spoken about in a lecture in memory of Justice Bhagwati than on the fundamental rights? And who's better to speak on the fundamental rights than Mr. Tushar Mehta, who's actually the state's voice in the court, the state which is supposed to be the guarantor of the fundamental rights. It's a perfect match. Everything has fallen in the right time at the right space. Thank you very much.
Thank you so much, Professor Srijit, for what I can say was the most wonderful virtual tour of Justice Bhagwati's great journey in law and life. Thank you so much. I now welcome Mr. Tushar Mehta, Solicitor General of India, to please deliver the Justice P.N. Bhagwati Memorial Lecture on the topic, The Journey of the Supreme Court of India on Fundamental Rights. Welcome, sir.
Good morning, friends. In fact, almost good afternoon. The legendary Vice Chancellor, Dr. Rajkumar, the graceful lady Sonali ji, daughter of the legendary Justice Bhagwati, Surbi, Srijit ji, Patnaik ji, and Dr. Khushbu Chauhan, and my young friends. Speaking about Justice Bhagwati is by itself an honor, and by organizing a lecture in memory of Justice Bhagwati, we are not honoring Justice Bhagwati, we are honoring ourselves. I had an occasion to meet him on quite a few occasions, and my feeling after meeting him was that of an inferiority complex. You are not impressed by the man only, but you feel inferior without any attempts being made by him to make you feel inferior, and that's the greatness of the man. Sonali ji must have seen Mr. Bhagwati, and therefore she would possibly not know what Justice Bhagwati, the phenomena, the living legend of the time, was. He was an institution in himself, and it's an honor for me to deliver this lecture. Now, coming back to the topic. The topic is Journey of the Supreme Court on Fundamental Rights. It's a journey of the Supreme Court, and therefore I would, given the constraint of time, make the journey a little fast track. But at the end of the journey, you will find that the journey of the Supreme Court in the case of fundamental rights have been a constant struggle, a constant fight, a constant conflict between the majoritarian government and the custodian of the fundamental rights, namely the highest court of the country, the Supreme Court of India. All of us are aware that our constitution is framed by the Constituent Assembly. How did we get the independence? Of course, I presume most of you are law students, but just for the purpose of record, let me say, it doesn't happen that Lord Mountbatten would hand over something to Jawaharlal Nehru and India would become free. Everything happens by some statutory enactment, and this happened by the Indian Independence Act, 1947. It was under that act that India attained independence, and became an independent sovereign nation. Section 8 of that act provided that the constitution would be framed by the Constituent Assembly. Constituent Assembly was formed by way of an election. Election took place under the Government of India Act 1935. But now comes the relevant part. Under the Government of India Act 1935 passed by the British Parliament, the voting rights were available only to taxpayers and those who are graduates. It was not universal adult franchise, and therefore the Constituent Assembly was elected by only 16%, 16% of the total population of independent India. We are aware that by and large, everything was there under the Government of India Act 1935, which was the basic foundational framework for the Constitution of India. But we as a nation were so lucky that our founding fathers and mothers of the Constitution were so visionary that they took 3 years, almost 3 years, to draft one of the most beautiful constitutions in the world, taking not only good things from the United States Supreme Court, but the latest one was the Supreme Court, the Constitution of Japan, which was incorporated a year before our Constitution was adopted. In fact, Article 21 of our Constitution, which is the heart and soul of our Constitution, is bodily lifted from the Constitution of Japan. By and large, the total scheme, the overall scheme of the Constitution of India is based upon the Government of India Act 1935. I'm not saying it's copy-paste or its adoption, but the basic foundational theme is that. There was only one difference. Under the Government of India Act 1935, there was no chapter of fundamental rights because we, Indians, were subjects and not citizens. Our Constitution was making us citizens and we were no longer remaining subjects. Therefore comes the most important part in the Constitution, namely the fundamental rights. I'm not going into the details of fundamental rights. It starts from Article 12 and goes on. Article 12 defines fundamental rights would be available against the state. State does not necessarily restrictively mean the central government and the state government. It can mean even government corporations, statutory bodies, universities, etc., etc. The most important article which would be necessary for the purpose of today's lecture is Article 13. If I can request, Article 13 can be shown. I'll not take much time. I am aware of the time constraint, but Article 13. Surbi, can you just help me with Article 13? I am technologically challenged. Just read Article 13(1). All laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of this part, and this part means Chapter 3, Fundamental Rights, shall to the extent of such inconsistency be void. 2 is important, and there was a conflict, which I will explain in a very nutshell. The state shall not make any law. There is a constitutional embargo, a constitutional mandate, a constitutional injunction. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of contravention, be void, meaning thereby it is a constitutional declaration that first, neither the parliament nor the legislature would make any law which does not conform to the fundamental rights chapter. And if any such law is made, court will declare that law to be unconstitutional. That's the mandate of Article 13. Now, up to the year 1951, the Constituent Assembly continued as the Parliament, because the Parliament was first elected in 1951. I'm giving the history, how the fundamental rights are shaped. Nehru was the first Prime Minister, and Nehru's dream was agrarian reforms, which was the need of an hour, because when India became independent, there were jagirdaris. The person would own hundreds of acres of land, bonded labor, people working on the field not getting sufficient, and therefore agrarian reform was the national priority. And therefore, the Constituent Assembly, acting as the Parliament, passed agrarian reform laws, which came to be challenged before 3 high courts. Madhya Pradesh and Bihar dismissed the challenge, and Allahabad High Court, Madhya Pradesh and Bihar upheld the challenge, rejected the challenge, and Allahabad High Court accepted the challenge. What to do? The challenge was accepted on the ground of Article 13, that this takes away, this is contrary to the fundamental rights. Then comes the first amendment of the Constitution. India is the only country where the first amendment of the Constitution is made by the Constituent Assembly itself, of course acting as a parliament, not in its capacity as the Constituent Assembly. This first amendment brought Article 31A, capital A, and 31 capital B. Now I'm not showing it. It's there here. Thank you, Surbi. But you need not read the whole thing. But Article 31A passed by the Parliament to overturn 3 decisions of 3 high courts. They said that fundamental rights will not apply if it comes to agrarian reforms, meaning thereby the Parliament decided that if we make a law in furtherance of agrarian reforms, it can even affect the fundamental rights of citizens. Meaning thereby, if your land is taken away arbitrarily, arbitrariness is violation of Article 14, you can do nothing. If your land is selected discriminatively, your neighbor's land is not taken, but your land is taken, that's violating Article 14, you can do nothing. Your land is taken away without paying any compensation, again violation of your fundamental rights, you can do nothing. The Parliament did this. Now this, and 31B. 31B was more draconian. How the majoritarian government works to deal with inconvenient judgments or judicial pronouncement of the judiciary. They say that so far we have only 8 schedules in the Constitution. After the Constitution ends, there were 8 schedules. They incorporated a 9th schedule, and Article 31B, which was introduced by the First Amendment, said that if any law made by the Parliament is put in the 9th schedule of the Constitution of India, then the effect of any Supreme Court judgment or High Court judgment will be wiped out. I am paraphrasing it. It means this. 31B is, the language says something else, but this is what it means. Now, these 2 amendments came to be challenged before the Honorable Supreme Court in Shankari Prasad's case. I am not going into the citation and para numbers, etc. This is not a class that way, and I don't want to bore you by giving unnecessary details. Now the question, the argument in Shankari Prasad case was that Article 13 says, now listen to this very, very carefully, because this is a very interesting beginning of development of the constitutional jurisprudence. The argument in Shankari Prasad case was that what are we challenging? We are challenging the constitutional amendment. What is the embargo under Article 13? Parliament cannot make any law which takes away the fundamental rights. Would a constitutional amendment be law within the meaning of Article 13? Because Parliament has two powers. One is constituent power, that is amending the constitution. And second, it's legislative power, that is making law. What is prohibited according to the government of the day under Article 13 was only law made by the Parliament and not the constitutional amendment. They relied upon Article 368, and 368 said that this is the Constitution of India, this is Article 368. 368 provides for amendment. The procedure for amendment is prescribed. In some cases, only Parliament can amend. You don't have to go to the state legislatures. There is a 2/3 majority contemplated. In some cases, you need ratification by 1/2 of the legislative assemblies, meaning thereby Parliament can amend the Constitution. Why not? Because the Constitution itself so permits. Therefore, Shankari Prasad says that Parliament has the power to amend the Constitution, and the law within the meaning of Article 13 would not include a constitutional amendment made under Article 368 of the Constitution. Now, this position continued for 14 years. The Parliament kept on passing. This is what majoritarian government does. When you have the majority, they kept on passing several legislations and kept on adding them in the 9th schedule. 9th schedule was kind of a safe harbor, a shield that court cannot examine the validity of that on the ground that it violates fundamental rights of the citizen. And mind you, fundamental rights are not given to us. Fundamental rights are the rights which we have reserved for ourselves. That's the theory, that's the philosophy. And therefore they are sacred, therefore they are sacrosanct. But the Supreme Court, speaking through a 5-judge bench judgment, said that no, that's not the case. There is a power of amendment, that's enough. Now, then comes Sajjan Singh's case. Again, 1965, 5 judges bench. Supreme Court, you know that whenever there is a question of constitutional interpretation, it goes to a 5-judge constitutional bench. There, Shankari Prasad is accepted. The view which I have said is accepted by a majority of 3-2. But the important part is two important dissents. First dissent was by Justice Hidayatullah, who later on became the Vice President of India, became Chief Justice of India, and thereafter became Vice President of India. He says, look, I am not a grammarian. I am not going by the grammar. I am not going by the language. I am going by the philosophy behind Article 368. You cannot do anything which abridges or takes away fundamental rights of the citizen. And therefore, I am not in agreement. Second minority was Justice Mudholkar, one of the less celebrated judge, one of the judges whom we have not done justice to by remembering him, but he was the first judge who for the first time used the term basic structure. Very few people take note of this fact that it was Justice Mudholkar in 1965 who said that there is a basic structure of the Constitution which cannot be tinkered with, even if you have a power of amendment. that is Justice Mudholkar. But ultimately, it survived the test, and Shankari Prasad was affirmed. Now matter goes to 11 judges bench when Justice Subba Rao was the Chief Justice, and by that time, Mrs. Gandhi was the Prime Minister. Whenever I refer to the names of the Prime Ministers, don't take it as any political reference, but it has its own relevance. What the majoritarian government can do, that's not my subject, but what the Supreme Court can do when a majoritarian government does something to do with your fundamental rights. When the Supreme Court comes, stands between the government and the citizens and protects your fundamental rights. Justice Subba Rao refers the matter to 11 judges bench in Golaknath's case. There is one small trivia which is reported in several journals, etc., but possibly you may not find it. Nani Palkhiwala was requested to argue. Very ironically, he was in Geneva arguing the case of the government of India. And he was requested to come and argue against this particular amendment, this particular position in law. He came. On that date, he had only one day, then he had to go because his arguments were going on in Geneva. Mr. M.K. Nambiar was arguing and he was on his legs. In legal parlance, on his legs means his arguments are going on. And M.K. Nambiar is no one else but father of our former Solicitor General, K.K. Venugopal, a very eminent constitutional lawyer. He was requested that Nani Palkhiwala has come only for a day, if you can accommodate, which generally is a little insulting for a lawyer. But the magnanimity of N.K. Nambiar, he said, I'll do something without compromising my position. So he started the argument, judges started putting questions, and he said that, sir, answering these questions might need a day or two for me. I'll have to formulate. If your lordship permits, Mr. Palkhiwala can in the meanwhile address, I'll find out the answers. He argued the 11-judge judgment and argued that though there is a power of amendment under Article 368 of the Constitution, there is always an implied limitation on exercise of that power. There are certain limitations which are either implied or express. There is no express limitation. You can alter the entire Constitution if the conditions under 368 are met. If the procedure is followed, you can entirely amend the change the structure of the Constitution. So he propounded the theory of an implied repeal. He also argued that Article 13 must include constitutional law also, meaning thereby, as I read Article 13, sub-article 2, no law can be made which takes away or abridges the fundamental rights of the citizens, and therefore, even if there is a constitutional amendment, if it takes away Part 3 rights, the fundamental rights, that law would fall foul of Article 13 and therefore will have to be struck down. Now, with a razor-thin minority of 6 by 5, the argument was accepted. 6 by 5. 6 held in favor of what Nani Palkhiwala and others argued, that yes, constitutional amendment stands on a different footing. It cannot take away the fundamental rights, and if it does, then it will be struck down. Now see how the parliament reacts to it. It was a majoritarian government. Mrs. Gandhi was all-powerful. She had the strength, numerical strength in the parliament and also in the state governments. She brought the infamous 24th and 25th Amendment and introduced Article 31C. Several amendments were made. But 31C was immediately after Golaknath case, 6/5 majority. It says this: notwithstanding anything contained in Article 13, no law giving effect to the policy of the state towards securing, ignore the bracket, all or any of the principles laid down in Part 4, I'll come to what Part 4 is, shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or Article 19, and no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy. Two things she did. There is a chapter 4, every one of you know. Chapter 3, fundamental rights, enforceable by law, enforceable by the courts. Chapter 4, directive principles of state policy. They are broad policy issues on which the government is expected to work but not enforceable. What was done by 31C was that A, if we do something in furtherance of chapter 4, namely directive principles of state policy, it will not be challenged on the ground that it falls foul of Article 14 and Article 19, number one. Number two, the law, if mentions that this law is in furtherance of Part 4, it's an end of the matter. Court cannot go into whether it is really in furtherance of Part 4 or not. Now, this again came to be challenged in the celebrated judgment of Keshavanand Bharati, 13th judge, for the first time, and so far the last time. So far there has never been 13th judge bench judgment. See, there are certain things which happens by sheer luck, providence. The matter was initially to be argued by Justice Chagla. He was practicing lawyer then, the former Chief Justice of Bombay High Court. So people approached him, eminent lawyers approached him. He said, I'm too old, I can't carry burden of a 13-judge bench, and it's a huge matter. Then people went to C.K. Daftari, the first Solicitor General of India after independence. He was in private practice then. He also said that I'm too old, I can't take up this responsibility. Let's request Nani Palkhiwala. Nani Palkhiwala was nowhere in the picture. And they requested Nani Palkhiwala to take up the case, and therefore it fell into his lap. And the history was created. Out of 66 days of argument, 32 days Nani Palkhiwala argued. What was the problem before him? The problem before him was an 11-bench judgment which said that if there is a power to amend, and if the condition specified for amendment is satisfied, Constitution can be amended. Why not? There is no concept of basic structure or basic feature in the Constitution itself. How do we define such a basic structure doctrine? Nani Palkhiwala started giving examples, and that shook the bench. He said that, for example, the preamble says that India shall be a sovereign democratic republic. Sovereign means now the power is vested in the people of the country. We are an independent nation. Suppose tomorrow the parliament were to pass an order, pass a legislation amending the constitution saying that the word sovereign is deleted. We are happy to be a colony of the British, as we were earlier. Would you permit? It was a question, and a real question. He said, India is a sovereign democratic republic. Today we have accepted the position of universal adult franchise. Every adult citizen is entitled to vote. Now tomorrow the parliament comes out with a constitutional amendment saying that only those who are graduates will be able to vote. Will you permit that? There are 500 plus princely states which we have gathered together. Many of the former kings are contesting elections. Suppose they form a majority in parliament and say that we are happy with the monarchy system. Earlier there used to be provinces. We will continue to be monarchs under either the government of India, which will be a former head, or under the British crown. Why not? Would you permit? And the judges were taken aback that now we will have to go into the basic structure doctrine, that there are certain basic concepts, basic notions, basic structure which cannot be altered. He said, how do you define basic structures? Nani Palkiwala gave 12 instances. I'm not going into that because that would become a class for constitutional law. I'm not on that. He said 9 can be derived from the preamble itself. Sovereignty, democracy, republican form of government, etc., etc., etc. And 3 can be derived from Article 368 itself. 368 itself says that certain things cannot be done. That's more on the academic part, and I'll not go into it. Again, this Keshwanand Bharati case is decided by a razor-thin majority of 7-6. Out of 6, 4 honorable judges said that there is nothing like basic trust doctrine, basic structure doctrine. We don't accept this basic structure doctrine. If there is a power, there is a power of amending the constitution. There were 4 honorable judges who said that. There was one more in 31C. Where in 31C, if you can. It provides, it's not mentioned here because it came by way of an amendment. It said that once we say that this law is made in furtherance of chapter 4, that is to give effect to the directive principles of the state policy, court cannot go into it. I've shown that. Justice Khanna, the present Judge Justice Sanjeev Khanna's uncle, the celebrated judge who lost his Chief Justiceship because of the stand which he took in favor of the citizens of the country, said one more ground 31C is bad because you cannot take away judicial review. Since 31C, Article 31C says that even court cannot examine, it violates the basic structure because I read judicial review also to be a part of the basic structure of the Constitution. All this was going on and the elections came. Again, this is not a political statement, but a fair, factual narration which is necessary to come to the next judgment as to how fundamental rights are protected. As you are aware, Mrs. Gandhi lost the election. She claimed emergency and she came out with 39th constitutional amendment. Now, 39th constitutional amendment, according to me, as a student of law, is the most draconian amendments passed ever. What 39th constitutional amendment said? That in case of Prime Minister and the Speaker, please listen this carefully. In case of a Prime Minister and a Speaker, if their election is set aside by the High Court is the only court which has the power to set aside the election. If in these 2 cases, High Court set aside the election, the order of setting aside election shall not take effect unless it is examined by the Supreme Court of India based upon the law which is yet to be made. There was no law made. But you can make a law that on A, B, C, D, E, F grounds, elections shall not be set aside. Then the Supreme Court had no jurisdiction to do anything but to say that the order of the High Court setting aside election is set aside. Complete immunity from election being set aside by the High Court in its judicial capacity. This came to be challenged again, and matter came before the 5-judge bench. Now, very interestingly, as I said, in Keshwanand Bharti, it was 7 versus 6, and out of 6, 4 minority judges have said that there cannot be anything like basic structure. Even they were shocked. And they also held against the government. They said, this is something which is not tolerable. Of course, they said it on different grounds. For example, Chief Justice Ray says that this amendment abrogates rule of law, and therefore it's not acceptable. Justice Matthews, he says that this is undemocratic because an elected person's election can always be set aside by a procedure prescribed by law or the procedure known to law. Justice Khanna says this is against free and fair elections, and therefore it should be set aside. And Justice Y.V. Chandrachud said that how do you distinguish between Prime Minister and Speaker and rest of the members of Parliament? Therefore, this is discriminatory and I set it aside. They don't say that this is a part of basic structure, but they were convinced that this is something which Nani Palkhiwala was alerting us with, and that has come true. And therefore, 39th constitutional amendment was set aside. Now something happens, and this again you will not get from, I'll request all law students. There are many things which I cannot speak from any podium, not this podium, any podium. But Keshwanand Bharti case was argued by Nani Palkhiwala, assisted by one eminent counsel who became eminent counsel later, but a very young counsel then, called Tempton Andhyarujina, who became a Solicitor General, my predecessor. He has written a book on Keshwanand Bharti case. It's a 120 page book. It's a first-hand information, and I can assure you, Tempton Andhyarujina is not something like a gossip monger. He's a very sincere and serious kind of a constitutional lawyer. And he has revealed shocking facts, which all of you must read. What happened during that duration when Keshwanand Bharti was being decided, what manipulations the government was doing with the judges comprising the bench. But I'll leave it at that. Please read that book of Tempton Andhyarujina. But one thing is on record, and therefore I can say, after the judgment was delivered in Keshwanand Bharti's case where government lost badly, Chief Justice Ray suddenly constituted 13 judges bench with some new judges on the bench. Everyone was taken aback. Nani Palkhiwala was again called that you have won a huge victory for the citizens of India, and we do not know why the Chief Justice has placed it again. So Nani Palkhiwala started making his submissions, and since judges were new, the question arose, why this matter is listed, by the way, because new judges would obviously ask. That compelled the Chief Justice to answer, because the Chief Justice constituted the bench. He said, Mr. Palkhiwala, you requested. Palkhiwala said, I am not a fool. Why should I request? I have succeeded. Why should I request for a review? This is all recorded, and therefore I am saying. He said, possibly state of Tamil Nadu mentioned. The Advocate General of Tamil Nadu gets up and says that we never mentioned this matter. Justice Ray said, maybe some other state government may have mentioned. Advocate General of Gujarat, J.M. Thakur, the legendary J.M. Thakur, he got up and said that I have inquired from every Advocate General, no state has mentioned. Next day, the bench assembles, Chief Justice Ray comes on the dais and says, bench dissolved. Because there was no answer. That's how Keshwanand Bharti is saved. Otherwise, it was stated to be under some influence, sought to be reviewed. Now what happens? Mrs. Gandhi comes with yet another amendment, that is 41st constitutional amendment, which says that if you are a president, prime minister, or governor, if you commit an offense, you can never be prosecuted even if after you cease to hold that office, because she was facing some criminal cases. 41st constitutional amendment. It was still at the stage of a bill and had not passed. It became an act thereafter, but Janata government also, because of their own lack of strength, could not do anything. No, this was again a draconian provision, because for Prime Minister there is a duration. You are a Prime Minister for 5 years unless removed. For President, 5 years unless removed. But Governor can be Governor for a day. You become a Governor for a day, commit some offense, and you are completely immune from any criminal prosecution for the rest of your life. That again came to be challenged. And Mrs. Gandhi introduced 2 sections in Article 368. Now see, the government reacts to the judgment of the Supreme Court. Repeatedly, I have shown that the Supreme Court says something, government comes out with an amendment, and this is what the amendment was, Article 368. So we directly go to 4 and 5. This is added. Sub-Article 4 and 5. This was added by way of an amendment. Four and 5. I'll say orally what it says. That doesn't matter. Don't take trouble. Don't take trouble.
I think this is the last slide, which is why it's ending.
That doesn't matter. Doesn't matter. Subsection 4 says, if Parliament amends the Constitution, no court in the country can judicially review the validity of that Constitution. Because now you are saying that 368 is the power, that's a source of power to amend the Constitution. Now we are putting a restriction on your power, that is the court's power, that you cannot judicially review. And 5 says, there is no limitation on the power of Parliament in amending the Constitution. So out goes the basic structure doctrine. We can do anything we like, and you cannot examine. That is, in substance, sub-article 4 and sub-article 5 of Article 368. Now, this came to be challenged. This is the last judgment I am citing. I am aware of the time limit and time constraints and your tolerance capacity also. Minerva Mills judgment. This was challenged in Minerva Mills judgment, and in Minerva Mills judgment, the 5-judge bench struck down sub-article 4 and sub-article 5, and one of the concurring but the most learned judgment in Minerva Mills case was delivered by Justice Bhagwati. We started with Justice Bhagwati, we are ending with Justice Bhagwati, but now see this. After the Minerva Mills judgment, the law is fairly settled that you cannot touch the fundamental rights. Thereafter, fundamental rights are given several dimensions. It has been expanded, and the last judgment, Justice Puttaswamy judgment, privacy is a fundamental right. There is a right of privacy even in the sex workers, etc., etc. Environment is a fundamental right. Right to food is a fundamental right, etc. There is only one constitutional amendment which came to be challenged after 2014. That is after the present government came. That was National Judicial Commission Act, NJAC. There was an act that not 5 judges, but one representative of the government, law minister, should also be a part of the collegium, which was set aside by the 5 judges bench with 1 judge dissenting. But the matter is left there. There is no reaction by the parliament, that is by the government, conflicting with the Supreme Court. Friends, why I say this? All of you are young people. All of us are. In fact, I am also young. Why not? But relatively, rest of you are young people. You have your own notions. You have right to criticize or support. But both your criticism and your support should be informed criticism and informed support. One of the purpose of showing the history of this constitutional fundamental freedoms and the protection given by the Supreme Court of India, standing between the majoritarian government and the citizen, was to show that there was a constant arrogant reflections or reactions by the majoritarian government, and the Supreme Court stood by it. More you will read in the book of Mr. Andhyaru Jina. It's written some 25 years back, immediately after the judgment, or maybe 5-7 years after the judgment. This is the history, and now we are fully protected. Only thing, last 2 minutes, many a times, Justice Bhagwati is the pioneer of the PIL jurisdiction, or the conventional notion that their person has to have a locus standi is diluted and almost given up by Justice Bhagwati. Why? There were people who were not in a position to approach the court of law, so somebody else can. He did not have the wherewithal to file a petition, engage a lawyer. He was not aware of the technicalities. He may even write a postcard which was treated as a petition. Now, when we see motivated and sponsored petitions, I always remember Justice Bhagwati, and I am sure today if Justice Bhagwati would have been on the bench, he would have delivered a landmark judgment restricting such misuse of PILs. The towering personality the man was. That is my confidence. Friends, I am thankful to this great institution, and I'm thankful to all of you. It's very difficult. As a student, I have been listening to such lectures, and therefore I'm aware of the torture which we have to suffer, but I have tried to be as less boring as possible. I'm thankful to Dr. Rajkumar, because I was just telling him that money can build institutions, build buildings, but not institutions. It's his vision which has created kind of an empire. And I always jokingly say that considering your presence in more than 75 countries, I think, 75 countries, he is on a reverse colonization. So the days are not far that Jindal may be known as India's Oxford. Thank you so much.
Thank you so much, sir, for such an impassioned lecture and for sharing your profound insights. I would hardly call this torture. Maybe nobody in this room has had the opportunity to hear such important things from the Solicitor General of India. So thank you so much. We will now have a short questions and answers session. I invite members of the audience to please ask any questions that they may have. I request Professor Raj to please take over.
Let's start with Professor Kagesh Gautam, who is himself a constitutional lawyer, and then we'll move to students.
I have only one question.
Yeah, please.
And I'd like to start exactly from where you ended. It is a concern, the matter of PILs, exactly as you said. Something has to be done about it. Now, you predict that Justice Bhagwati would have probably passed another judgment restraining the scope. I wonder what your thoughts are on the use of international law to interpret the Constitution and how Justice Bhagwati would have probably responded to it, given that the court is in cognizance of very sensitive matters that are going to be coming up very soon. So wanted to know what your thoughts are on that.
As you said, lastly, there are sensitive cases which are yet to come up and I am appearing, so I would have some limitations in answering. But I would say one thing with confidence, that jurisprudence of every nation develops based upon its cultural ethos, its past, its societal values, etc., etc. The international law doctrines, some doctrinal approaches, some foreign jurisprudence, etc., would have been discarded by Justice Bhagwati. Justice Bhagwati has always evolved India's own jurisprudence rather than adopting or mechanically following jurisprudence, say, by the United States Supreme Courts or European Commission of Human Rights, etc., which at times, in the Indian context, we feel are taking extreme positions, which we may perhaps not agree as a nation. I'm not on government or ideology, but as a nation, it may not be appropriate for us to accept and agree to those notions.
Good afternoon, sir. Sir, since the lecture is on journey of Supreme Court on fundamental rights, I remember reading recently, I think last year or this year, the court said that fundamental rights can be enforced against individual parties, like I think in the Kaushal Kishore judgment. So how does that represent the journey from, like we did till Keshav Nanda? Is it the next step, and what kind of a change does it represent in fundamental rights and dealing with citizens? Especially how would Justice Bhagwati read it as well?
My name is Tanvi. I'm a fourth-year law student. So I just want to understand, when you stated like with every Supreme Court judgment, who the Prime Minister at that relevant time was, and that it was not to state the politics of that situation, but the general relevance. I still don't understand how do we keep politics like aloof from the Supreme Court, because at the end of it, that relevance is political relevance. So I think I just want to understand your views that how is it that you maintain that independence of judiciary and that there is still separation in the manner that politics does not enter the realm of judges and does not affect their biases.
Good one. And then we'll take one more and then we'll have him answer.
Good afternoon, sir. Thank you for the wonderful lecture. I'm Gitanjali from the second year LLB 3-year program. So the question that I've been pondering upon is with regards to how fundamental rights takes shape in terms of national interest and public interest coming into play, especially in a very digitally driven world that we live in. So how does that shape out when it comes to terms related to privacy or anything which could actually have a significant impact on the citizen per se?
I didn't say that there is always, whoever is the Prime Minister, there is some kind of an interference. It depends upon the Prime Minister and Prime Minister. There were and there are who never interfered with the judiciary. Number two, we can do nothing about it as citizens of the country. It's for the executive to draw the Lakshman Rekha, and it's for the honorable judges to maintain that distance. Without distance doesn't mean that you don't talk to each other. You have to discuss. For example, Chief Justice has to discuss so many things with the Law Minister in terms of grants, in terms of digitization, in terms of several administrative issues. But they are matured enough to maintain that distance. By and large, I have not seen any deviation from the separation of powers. Because what happened in the past was so gloomy that the shadow still remains, and therefore both executive and judiciary are conscious that we cannot cross this Lakshman Rekha. At times, we feel that the judiciary crosses Lakshman Rekha by encroaching upon the field reserved for the executive. For example, you are not supposed to manage COVID. That's for the executive to do, but some judges used to do. But with some exceptional situations, there is a separation of power. First question, the Supreme Court has not said fundamental rights are enforceable even against the private parties. What the Supreme Court has said, that fundamental rights are enforceable against a private party if that private party is discharging public functions. Because if suppose there is a dispute between husband and wife, there may be some action of the husband which might be arbitrary, irrational, discriminatory, etc. Wife can't invoke Article 14 against purely private individual. But suppose I am a liquidator of a particular corporation. I am a private individual otherwise. If I am acting in my official capacity, then fundamental rights can be enforced against me. Your question was balancing of fundamental rights. more particularly in light of the digital era which we have already entered. Now, this is an evolving jurisprudence because there is a conflict between my right to know, which is my fundamental right, and his right to privacy. To what extent my right would intrude upon his right is a question of balancing competing fundamental rights. There is a concept of competing fundamental rights. For example, it's a matter pending, therefore I will not dwell much, but suppose there is a complete fake news. There is a competing fundamental right. The right of the citizen to know whatever is printed, at the same time, right of the government to inform the citizen that what is printed is not true. So the court will have to balance it out. And therefore, the court has evolved the theory of proportionality. That proportionality test has to be examined if there is what they call legitimate state interest, then even a fundamental right can be encroached upon. It's not encroachment, but it's putting a permissible limitation on the fundamental right. So it's more a question of balancing the competing fundamental rights. And that's jurisprudence is evolving.
Good afternoon, sir.
Yeah, good afternoon.
My name is Rukmini Pradarshini Das, and I am currently in my third year of the BBLB law program. It has been an absolute blessing to be enlightened with your elixir of knowledge. And while hearing you today, it made me hark back to Dr. Bibek Debroy's Khaitan Endowment lecture on the theme of reform of the Indian legal system. And we have had the good fortune of interacting with him on the sidelines of that lecture. And I just remember him saying that we are, doing really well when it comes to reforms, and then all of us just go out of the auditorium and open our phones and see that in the parliament the three new criminal law bills on the same date have been tabled. So being an absolute fan of his work and a regular viewer of his show Itihas, I regularly follow his news articles, and 3 days afterwards on August 14 I come across one of his articles in the Live Mint titled as "There is a case for we the people to embrace a new constitution." And there it has been specifically mentioned that amendments will not do the work, because when we have to go back to the drawing board and start with the first principles, and also the fact that after 1973 when we are not in a position to amend the basic structure, that's why there is a case for we the people to embrace a new constitution, to abjure our colonial past and reclaim our heritage. So right now, I have been very inquisitive as to what Dr. Bhagwati would have had the opinion on with respect to this.
See, I am never a proponent of changing the entire constitution. I don't think Dr. Debroy also intended to say that. It can never be, for the simple reason that if you go through the Constituent Assembly debates, our constitution is not legacy of the colonial era. There is a serious application of mind by eminent intellectuals who were forming part of the Constituent Assembly. So there is no question of, there might be some tweaking required because the Constitution is ultimately a living document and it must reflect the position as it exists today as compared to what it existed before, say, 20 years. But there is no question of going back to the drawing board and starting all over again. It is a constitution which is here to stay at least for 200 years. It's our people who drafted it were visionaries.
So I quote him verbatim when I say that amendments will not do if we need to go back to the drawing board and start from first principles. I quote him verbatim here.
I do not know in which context he said, but I'm sure he would not be, we would not have meant
Definitely.
effacing the constitution and starting with a new document. I don't think he would ever do that. Definitely. I know the gentleman very personally, and I don't think that's his view.
Definitely. Thank you so much, sir.
Thank you.
Very good afternoon, sir. My name is Prince Daya, and I'm first year LLB student. And I want to ask a question regarding the fundamental rights. But today, taking this opportunity, as Solicitor General of India, you will be taking stand on certain matters where you yourself feel a dilemma that which side is correct and which side is wrong. How do you cope up with such stress? And we, being ought to be a good lawyer, how would you suggest us to cope up with that situation?
I'll give you an answer. Uh, we had, as I quoted Mr. Daftari, the first Solicitor General of India. He was known for his immediate, quick wit and repartee. He was briefed in a matter. He gets up, and the judge asked that, Mr. Daftari, what is your personal view about the matter? He said, my lord, there is nothing in the matter, nothing in this appeal. Then why did you advise your client not to file it? He said, my lord, my clients wanted your advice, not mine. See, as lawyers, we are not supposed to give our personal views. We are not engaged to give our personal views unless the stand which you are expected to take, that happens generally in private practice, is so diametrically opposed to your personal value system. You are supposed to represent the client. I mean, you need not agree with whatever the clients are facing. You can defend it without being convinced yourself. And that's the real challenge in case of a government lawyer. He may or may not be convinced with what he is defending. That luxury is available only in a private case. Suppose a rapist come, you may say that prima facie, I feel you are guilty of rape, and doesn't my conscience don't permit me. I'll not take up your matter. But as Ram Jethmalani would say, that we are not supposed to be judges of our clients. Every client has a right to be represented, and therefore he never said no to any client. That it's for the court to decide whether he is guilty or not. My job is to establish that he is not.
I would like to respond to, with your permission, to the question on how Justice Bhagwati would have responded to the question. I think he might have said, justice, liberty, equality, fraternity, rule of law against rule of force, these are ideals which are ageless, and that is already enshrined in the Indian Constitution that was adopted by the Constituent Assembly. Thank you.
I think this is not my subject, and my understanding is limited to the social sciences done at school level.
Being daughter of Justice Bhagwati is good enough to know the law as well as we are knowing. You can go ahead.
So I just wanted to say that when you said that his jurisprudence was Indian, and that's where it evolved, and somebody once said about him that he is homemade and not homes made.
Wow. Absolutely right. Absolutely right. No, this has become now a trend, even amongst youngsters also, ma'am, because as Justice Bhagwati, so is in my case, we studied in an era where there was no internet, there were no softwares like SCC Online, Westlaw, which gives us the other jurisdictions' judgment, etc. And therefore, there was less of the dependence on jurisprudence of other jurisdictions. But now it's fashionable is not a correct word, maybe, but now it's in the language of this generation to cite foreign judgments. But I sometimes, and kindly pardon my words, but the example which I gave to the court also in the case of privacy is that you cannot blindly rely upon foreign jurisdiction for the simple reason that the concept of privacy in India and concept of privacy in, say, Europe or America is different. Here, we can piss in public place but not kiss in public place. There, we can kiss in public place. So, privacy concept can never be decided based on foreign jurisdictions. And that's what Justice Bhagwati has, in fact, in one of the judgments said, that never blindly follow judgments of other jurisdictions. We have our own culture, our own ethos, and our own jurisprudence, which must evolve itself to meet with the societal values of our society.
Just to complement what you said, Justice Bhagwati is homemade, but Justice Bhagwati has made phenomenal contributions in the international front.
Yes.
he organized in 1988 the Bangalore Declaration on the domestic application of international human rights
On
norms.
international platform, not as a judge of the Supreme Court. Yes.
So we have to acknowledge that he was
100%.
after he left the court, he was a giant in terms of shaping international law and norms.
Absolutely.
And giving guidance to courts on how you deal with international statutes, the conventions of the United Nations, and how you bring them into domestic application.
No, I never meant to say that he was obsessed with Indian dogmas. So long as he continued as a judge of India, he evolved his own jurisprudence. When he was on the international platform, he contributed on international level too.
As we come to an end to today's lecture, drawing deep inspiration from Justice Bhagwati's life, I'd like to thank Mr. Tushar Mehta for his gracious presence as always, and for sharing your most profound insights. Thank you, Professor Rajkumar, Professor Srijit, and Professor Patnaik for creating opportunities within our institution to continue to seek knowledge and experiences from legal stalwarts. Thank you to everyone involved in organizing today's lecture. Thank you, Sonali ma'am, for being here. It's been a pleasure to have you. And thank you to all our colleagues and dear students for your presence always, and to all our staff members and those working behind the scenes. Please take care and have a great week ahead. Thank you.